It says a deferred sentence is a sentence that is deferred while the defendant completes a period of probation. It may be granted if the defendant has pled guilty. If the defendant violates their probation, the full sentence may be instated. If the defendant fulfills their probation, they may have the incident lifted from their record. Do you have any plans to expand or develop alternative deferred sentencing programs? That's the first question. So we just explain it. And if we've not explained that correctly, please correct for the audience. And then secondly, what programs have you seen or heard that you would implement?
With a deferred probation, basically what happens is the defendant pleads guilty. The court accepts the plea but doesn't have a finding of guilt. And basically, it keeps them on the hook for that period of time. In regards to what have I implemented, I have a pretrial diversion program for young offenders, young adults, because as we know, technology follows you everywhere you go with the internet. And so bottom line is if they successfully complete the program, it's like it never happened. And they can come back in and they can get it expunged. I also have a veterans program that if the veteran qualifies, and it's not for every type of case, but if they qualify, what we do is the goal is to rehabilitate, and the goal is for them to be successful in the civilian world. And if they successfully complete that program, and it's a long process, and I'm proud to say that we spearheaded that program as the district attorney. If they successfully complete it, they too can get it expunged and be productive members of society. That's our way of saying thank you back to the veterans. Thank you.
Hey.
As Paul said, deferred adjudication is a probation where there is no adjudication or finding of guilt. The probationary period subjects the individual to the full range of punishment. In other words, if they're placed on deferred for a first-degree felony and they violate probation in any form or fashion, they can be sentenced up to life in prison or 99 years. That is up to the discretion of the judges as to what the ultimate disposition would be. Deferreds don't just go away. Some deferreds, not all deferreds, but some deferreds can be, you can file a petition for non-disclosure, and only law enforcement and licensing agencies in the state will have access to them. There are certain offenses that you can't get non-disclosures on. I think the diversion program is an excellent program in the appropriate circumstances. The veterans situation is very good. The law was passed in 2009. We just got the Veterans Court this year. I wish we would have had it longer, but I'm glad that we have it now.
Great. Karen?
Just for clarification, there's two different types of deferred. There's deferred through the court system, and then there's what's known as a pretrial diversion program. If you take deferred through the courts, you are not entitled to an expunction except through a JP court or a municipal court in a Class C. So if it's a B misdemeanor or above, there's no way to expunge that from your record. Pretrial diversion was actually started under Paul's administration, and I give him a great deal of credit for that. It's for first-time offenders. In certain areas of the law, if there is a deal struck with that first-time offender between the defense and the state, they will go on a probationary period that's outside of the court system, and if they successfully complete that, then the DA's office will either dismiss the case or not file the case if it's been caught prior to filing. And at that period in time, the defendant can then come back and pay more money and go through an expunction proceeding in order to get that off their criminal history. It is a one-time only get-out-of-jail-free card. I think that the district attorney currently does not allow DWIs and does not allow assault family violence cases to go through that pretrial diversion, and many defense attorneys disagree with that. I do not. I agree with the current district attorney that those are not appropriate pretrial diversion cases, and I think that I would continue, in fact, I know that I would continue not to allow those to be in the diversion program. What I disagree with is that felonies are oftentimes treated exactly the same as a misdemeanor through that probationary period. So if you have a usable quantity of marijuana, which can be a very small amount, or you have bags of marijuana, you're often treated the same. So I would make distinctions in how I treated different offenders under the pretrial diversion. But I think that it's a good opportunity for first-time offenders in Denton County.